Good morning, everybody. I'm Stephanie Martins. I'm the Director of Education for the Arcadia Association of Realtors, and I just wanted to thank you for joining us this morning and taking time out of your morning to be with us. At this time, I'll go ahead and turn it over to our guest speaker, Georgina Lepe, who is going to present on the importance of a trust in this pandemic. Thank you so much for being with us, Georgina.
Thank you for having me. All right, good morning, everyone. So I'm sharing my screen. Hopefully you can see my PowerPoint. Everyone can hear me. So we're gonna be discussing the importance of a trust in this pandemic. Like Stephanie said, my name is Georgina Lepe. My firm is located in Claremont. If you have any questions, I will take them at the very end, and you'll be able to submit them through the chat option of Zoom. However, during the presentation, do not submit any questions because I'm not going to be looking at your questions during the presentation. And it's very likely that during the presentation, I will address the question you may have. So just hold off and don't submit. Sorry, someone said they can't hear me. Stephanie, can you hear me? Okay, so yes, it's probably a setting in your computer. So just remember questions until the very end, and let's get started. So what does my office focus on? A third of my practice solely focuses on estate planning, creating revocable living trusts, pour-over wills, financial power of attorneys, advanced healthcare directives. When someone does not plan and doesn't have a living trust, then we end up in probate court. And that's also what my office handles. And then lastly, real estate litigation. Within my real estate practice, I do handle evictions, partition lawsuits when we're forcing the sale of a property. So COVID-19 and trust. So unfortunately, we are, living through this pandemic. None of us thought that this would happen. I never thought in a million years that the courts would literally shut down. People are in hospital rooms alone. No one is allowed to go in there and see them. So that's why trusts are so important in this pandemic, because let's assume that you were to contract COVID-19 and you're in a hospital room all by yourself, no one can visit you. Who would have the authority to make financial decisions for you? Who would have the authority to sign off on any documents that need your signature in order to move, one of your transactions along? Who would have access to your financial accounts? Some of you, it's just you on your account. You don't even have your spouse. You may have a beneficiary designation, but keep in mind that a beneficiary designation does not vest until you pass away. So while you're alive and breathing, whether you're conscious or not, someone needs to be appointed to be able to make those financial decisions for you. What about if it's for your parents? What if your parents pass away during this pandemic because they're elderly? Are their wishes written down? Are you, as their children, going to have to face probate because they did not create a living trust? These are all things that people should be thinking about, because from one day to the next, everything may be great, and then the next day you're stuck in a hospital room, unable to see anyone. So today's agenda, first we're going to go over some key terms. Next, we're going to go over the estate planning options that every individual has. The downfall of adding children to title property. I know a lot of my clients come in and they want to avoid the expense of creating an estate planning portfolio. When I say estate planning portfolio, though, that is comprised of all the documents that I prepare for my clients. The living trust, the pour-over will, the financial power of attorney, advanced healthcare directive, all those good documents that you'll need. The downfall of taking title is joint tenants. And then at the very end, I will be taking all of your questions. So key terms. When I'm referring to assets, I'm referring to your home, your rental properties that you own, your bank accounts, your business interests. So whether you have an S corporation, a C corporation, an LLC, any timeshares, investment accounts such as 401ks, things of that nature. What is a will? A will is a simple 2 to 3 page document that indicates how you would want your assets to be distributed when you pass away, and who's going to be in charge of the probate proceeding. So in a will, you nominate an executor. So when someone passes away and they have a will, we have to go through probate. The person that gets nominated in that will to be in charge of the probate proceeding is called the executor. And in that will, you obviously list your beneficiaries. Probate is a court supervised process that gets initiated when someone passes away with or without a will. In the probate process, if there is a will, the judge has to admit that will into probate and make sure that the will was executed pursuant to all the requirements in the California Probate Code. If someone passes away without a will, probate is still necessary because the judge needs to determine who the heirs at law are of that decedent. In the probate proceeding, obviously, if there is a will, the judge is going to appoint the person listed in the will as the executor, give that person the authority to gather all of the decedent's assets, either sell the assets or transfer them into to the name of the beneficiaries. Living trust. What is a living trust? It is an agreement that you and or your spouse, if you're married, you and your spouse will create this trust together. Or if you're a single person, it's an agreement that you create. In that agreement, you are the initial grantor, trustor, because you are in charge of all your assets during your lifetime. In that trust agreement, you nominate a successor trustee, someone to manage your assets in the event that you are to become disabled or pass away. In the event that you are to pass away, in that living trust agreement, you outline the instructions of how you want your assets to be distributed to your beneficiaries. So when clients come into my office, I always tell them you have 3 options when it comes to planning for the future and how you want your assets to be distributed. One option is you don't plan. You don't have a will, you don't have a trust, which I definitely do not recommend, because if you don't have anything in writing, laying out the instructions of how you want your assets to be distributed, then someone that you did not intend to receive your assets may end up with your money. So that's not a good idea. So if you don't have a will, you don't have a trust, and you were to pass away, someone, either a family member or a friend, would have to initiate the probate process in order so that the judge can appoint an administrator to manage your assets. That administrator would either list your properties for sale, liquidate the assets, transfer them into the name of your heirs, obviously once the court decides who your heirs at law are. The entire process takes about 1.5 years. This was pre-COVID-19. Now I'm thinking it's probably going to take about 2 to 3 years to close up a probate case. Why do you want to avoid probate? One of the reasons is the fees associated with probate. We as attorneys get a percentage of the total value of the assets. We are looking at market value. We're not looking to see how much you have in equity in a certain home. We are looking at market value. So if we're going to probate one home and that one home is worth $500,000, the attorney at least will receive $13,000. the personal representative, the person that assists the attorney managing the probate, receives the same amount. So 13 plus 13 equals $26,000. That's just to probate one home that's worth $500,000. Imagine if you have your primary residence and an investment property and they add up to $900,000, then you're looking about $42,000 in administration fees just for the attorney and the personal representative. That does not include the court filing fees, probate referee fees, any creditor claims, or Medi-Cal claims. In the probate proceeding, when we file the probate case, we actually have to publish it in a newspaper notifying all potential creditors that this person has passed away, and if they have a claim against this person, then they would need to submit a claim in the probate case so that they can get paid at the close of the proceeding. Also, before we close out a Medi-Cal claim, we need to notify Medi-Cal. So if you received any benefits from Medi-Cal from age 55 to the date of your passing, Medi-Cal can file a claim in the probate proceeding and get paid at the end of that case. So at the end of the day, it's likely that your adult children will probably end up with nothing. I have a probate case where the decedent had a reverse mortgage. So, and that was the sole asset, the primary residence with a reverse mortgage. So the children thought, okay, we initiate probate, we sell it, and at least everyone's going to walk away with a little bit of money. But that wasn't the case because Medi-Cal filed a claim and their claim was over $100,000. Literally, I'm not lying, I'm not exaggerating. I think it was like 130 to be exact. There wasn't enough money. So whatever we generated from the sale, we use that money to pay for my attorney's fees, to pay for my client as a personal representative, to pay all the court costs, and then at the very end, whatever was left, we sent off to Medi-Cal. So that's a perfect example where if the client had avoided probate, we did not need to pay Medi-Cal and the kids would have gotten, some money. But in this case, since we had to go through probate and we have to notify Medi-Cal, they end up getting paid at the end of the probate proceeding. So just a quick recap with option number 1, you don't have a will, you don't have a trust. Probate would be necessary in order for the judge to distribute your assets. Your assets will end up in the hands of whoever is your heir at law. So if you have 3 kids, even though you've had a falling out with one of your kids and you haven't seen them in 30 years, that person is still your heir at law. So they will receive a percentage of your assets, a third to be exact. If you're married, then everything goes to your spouse if it's a community asset. Option number 2 is having a will. You will hear people that will tell you, I have everything in order, I have a will. Great. You're still going to end up going through probate. The only benefit of having a will as opposed to not having a will is that in a will, you nominate an executor. You tell the court who you want to be in charge of your probate proceeding. And on top of that, you list the beneficiaries. You tell the judge who you want to receive your assets. So in the first scenario, you didn't leave anything in writing, so the judge is just going to distribute your assets to your heirs at law. In this case, you actually left instructions, but the downfall is we have to go through probate and pay the thousands of dollars in attorney's fees, court costs, and the filing of a Medi-Cal claim. So let's go over these scenarios. I put these together in case you were going to sell a home in the probate proceeding, or you actually had a trust and the home will be sold in the trust administration process. So let's assume we're going through probate. I'm going to focus on this middle part of the table. So the value of the home is $500,000. You still owe $200,000. The broker commission at 5% is $25,000. Closing cost, this is an estimate of $4,000. Attorney and representative fees, at least $26,000. Probate fees, at least $5,000. The heirs would split $240 because, we're dealing with the attorney's fees right here. This does not take into account if there's any creditor claims or Medi-Cal files a claim. On the other hand, if we had all your assets in the trust and we're avoiding the attorney's fees and we're avoiding the probate fees, then your heirs would be able to split $271,000. So that's a difference of at least $31,000. $31,000, that's a lot of money. You can buy a luxury vehicle. You can put down a huge down payment on a home. So when people come to me and they say, well, Georgina, I don't want to spend a couple thousand on your trust. I'd rather let everything go to probate. When you sit down and look at the numbers, it obviously does not make sense to go through probate because this is a $30,000 difference. And keep in mind that this calculation is based on the home values right now. When you pass away, your home that right now is worth $500,000 may be worth $800,000. So that only causes the attorney's fees to increase. So option number 3, and the best one. So when clients come into my office and I tell them, well, you have 3 options. 1 is not doing anything. 2 is preparing a will. And number 3 is preparing a living trust. Option number 3 is obviously the best option. And why is that? With a living trust, you can control your property while you're alive and able to do so. So remember earlier that I said that a living trust, it's an agreement that you create during your lifetime. So in that agreement, you indicate that during your lifetime, you are the owner of all your assets. So even though you create a trust, and all your assets get transferred into the trust, in the future, you can sell your assets, you can refinance, you can obtain a home equity line, you can do as you please. So you're in complete control of your assets. So with a trust, think about it as a bucket. During your lifetime, you're walking around with that bucket. In that bucket, you have the living trust agreement, which is the contract that outlines how your assets will be distributed upon your passing. And then all your assets, you transfer them into the trust. Trust needs to be properly funded in order to avoid probate. And when I say properly funded, I'm meaning that all your assets need to be in the name of the trust. So your primary residence, instead of it having your name, it should have the name of your trust. For example, my trust is the GL Living Trust. The title to my house reads as follows: Georgina Lepe as trustee of the GL Living Trust. Obviously, when I closed escrow, title was just in my name, in Georgina Lepe, but now it's title reads Georgina Lepe as trustee of the GL Trust or Living Trust. So that's what I mean, that all your assets need to be the name of your trust. Your checking and savings account should reflect the name of the trust. If you have an LLC or an S corporation, those assets should be assigned into the name of the trust. So during your lifetime, when you're walking around with that bucket, you're in complete control of all your assets. With the living trust, it allows you to take care of yourself and loved ones if you become disabled. The provisions in the living trust agreement provide that if you were to lose capacity and you can no longer manage your assets, the successor trustee will step in your shoes and be able to manage your assets. Let's say you're in the middle of closing escrow and then you lose capacity. Who has the ability to sign off on the remaining documents? Absolutely no one. But if you have a trust, the successor trustee would be able to do that for you. You give away your assets to certain individuals with your own restrictions. In the trust, you can indicate if you're going to disinherit a child. You can give different percentages to your children. We can even plan ahead. We indicate that if a certain person has passed away, then his or her share either trickles down to that person's kids, or it reverts back to someone else. So with a living trust, you place your own restrictions. Maybe, your kids are still small that you think to yourself, well, if I pass away and they are of a certain age, I don't want them to receive their inheritance outright. I want to stagger the distributions, and you can indicate at what ages and what percentages they will receive their inheritance. If any of you have a child of special needs, you definitely need to plan, because their inheritance needs to be placed in a special needs trust. Otherwise, they lose their government funding without unnecessary cost or undue delay. So only a properly drafted and properly funded trust will avoid probate. Sometimes you will encounter situations where someone has a trust, but they forgot to transfer all their assets into the name of the trust. So in that situation, you still end up in probate court, either in a full-blown probate proceeding or a summary probate proceeding. So you definitely have to make sure that all your assets are in the name of the trust. For those of you that currently have a trust, make sure that title to all your properties is actually in the name of the trust. Sometimes if you refinance during your lifetime, the lender will take the property out of the trust, and then you forget to transfer it back into the trust. So then you pass away and your children have to go through probate. So here's a chart breaking down the differences between a living trust and a will. Living trust avoids a costly and lengthy probate process. Remember, in the probate process, your children will not receive their inheritance until the very end, once the judge signs off on the order for final distribution. A will is a golden ticket to probate. Like I mentioned before, people believe that since they have their will, they have their affairs in order. But no, that's not the case. You're still looking at the thousands of dollars in attorney's fees if you go through probate. A living trust protects you in the case of a disability, like I mentioned earlier. If you're to lose capacity, the successor trustee can step in your shoes and manage all your assets and provide for your care during that time that you have lost capacity. A will does not plan for disability. A living trust, Medi-Cal claims are avoided because as of January 1st, 2017, an order was signed that if someone has a living trust and they're avoiding probate, Medi-Cal will not seek to recover against the estate. On the other hand, if you go through probate and you have received Medi-Cal benefits, Medi-Cal will file a claim in the probate proceeding. With the living trust, blended families are protected. In a will, children from families could be disinherited. Because even if you're married and husband and wife have their own separate wills, it doesn't necessarily mean that we're going to use both of those wills in the probate process. So if you have children from different relationships, they possibly will get disinherited. I'll give you an example. Let's say wife has a daughter from a previous relationship. Husband has a son from a previous relationship. And they don't have any joint kids. They buy a house and they buy it as joint tenants. So wife unfortunately dies very early on in a car accident. And then since the house is as joint tenants, husband is now the sole owner of that house. So husband continues residing in that house. 40 years later, after his wife's passing, he passes away. So in the probate proceeding, his will is presented. And in his will, he leaves his son as his sole heir. So husband's son is the only one that will receive title to that property because wife's daughter is not listed in husband's will. Obviously, wife's daughter was listed in mom's will, but since mom's will isn't being used because she wasn't the last one to die, then daughter is disinherited. How about adding your children to title of the property? I get a lot of clients telling me, you know what, Georgina, I don't want to spend a couple $1,000s creating a trust. I'll just add all my children to the title of my property. This is a great way to have your children's creditors go after your property. You know, what if your children get in a car accident and it's pretty severe that their insurance isn't enough to cover the damage? Now they're going to go after your property because your property is owned by your children. What if your child is involved in a divorce proceeding? Guess what the other attorney is going to do? They're going to place a lien against your home and involve you in the divorce proceeding because they're going to argue that the home that your children are entitled to is part of the divorce proceeding. You also lose control of your property. I have had clients be sued by their children to force the sale of properties. Clients would add their children on title with the intent that that house would go to their children when the parents pass away. However, during the child's lifetime, they get greedy and there's a falling out with the parents and they decide to force the sale of the property. So you definitely do not want to do that and have your kids possibly sue you in a partition action to force the sale of your home. Also, it is best to inherit a home than to receive it during your lifetime. When a child inherits a home, the value of that home gets determined at the time of the parents passing. So let's assume that my parents pass away and the home that I inherit from them is worth $700,000. So at the time of their passing, that home is worth $700,000. They pass away, I inherit that home, and I sell it for $700,000. What is my gain on that home, on that sale? Absolutely nothing. When I inherited the home, it was worth $700,000 and I sold it for $700,000. So I don't have to pay any capital gains taxes on that transaction. However, if my parents were to add me on title to their property during their lifetime, then I inherit their tax basis. So let's assume that when they bought that home, it was worth $70,000. And now it's worth $700,000 at the time of their passing. So when I turn around to sell that property, I'm going to need to pay taxes on the difference between the sales price of $700,000 and $70,000, which was my parents' purchase price. So here is a breakdown, obviously with different numbers. In this scenario, I indicated that my parents purchased the property in 1986 for $250,000. The parents add the children on title in 2010. By that time, the house is worth $500,000. The parents pass away in 2040. The house is worth $700,000. The children sell the property for $700,000. Their capital gains taxes is about $180,000. How is that calculated? We take the sales price of $700,000. We deduct the parents' purchase price of $250,000. That gives us a gain of $450,000. Capital taxes combined between federal and state could be about 40%. I think it's anywhere from 20 to 40%, depending on your tax bracket. So your potential tax liability is about $180,000. This is a lot of money. On the other hand, if the children inherit the home, their capital gains taxes is essentially zero. The parents purchased the home in 1986. The parents passed away in 2040. And at that time, the home was worth $700,000. The children sell the property in 2040. The value of that home was $700,000. So how do you calculate their taxes? The value at the time of death minus the sales price is zero. The downfall of taking title as joint tenants. We do not live in a perfect world. So I do have clients that will tell me, well, Georgina, I won't add my child on title. I'll just take title as joint tenants with my surviving, with my spouse. And then when one of us passes away, the surviving spouse will create a trust. Well, it doesn't work like that because we don't live in a perfect world. What if both of you pass away at the same time? What if by the time one of you passes away, the surviving spouse doesn't have capacity to create a trust? What are you going to do in that situation? Like I mentioned earlier, blended families are not protected because if someone passes away and they hold title as joint tenants with the other owner, title to that property automatically goes to the surviving joint tenant, and he or she can do as they please, and they can disinherit your children. Adding children as joint tenants will cause issues. So earlier I was mentioning what I mean with an estate planning portfolio. So it includes a trust, the pour-over will, a financial power of attorney, the advance healthcare directive, property documents, and deeds. So my revocable living trust is about 100 pages. The pour-over will is used in case something gets left out of the name of the trust. The financial power of attorney is about 25 pages. That financial power of attorney allows someone to make financial decisions over your assets that are not in the name of the trust in the event that you were to lose capacity. The advance healthcare directive allows someone to make medical decisions for you if you're unable to make medical decisions on your own. What is the price? For a single person with one home, it's $1,649. A married couple with one home, it's $2,499. For each additional property, it's $250 because we have to prepare the deed and pay the additional recording fees for that. So when you look at these numbers, compared to the probate fees, you realize that obviously it's very beneficial to have a living trust, especially in this pandemic, because you don't know, what if you contract the virus and you're stuck in a hospital room, you don't know for how long, and you're unable to have these documents prepared. So now I'm going to take some questions. So let me open up the chat. All right, where is the chat? Okay. Maureen, is it recommended for husband and wife to have two separate trusts? If spouses die, can other spouses change the trust? If the assets you're dealing with are a community asset, then it's okay to have a joint trust between husband and wife. What happens when one of the spouses passes away? It all depends what the trust outlines. In certain trusts, we indicate, hold on, let me mute someone because I'm getting a lot of noise over here. Okay, so in a trust, what happens when one of the spouses passes away? It all depends what the trust outlines. There's three options. One option is one of the spouses passes away, then everything goes to the surviving spouse and they can do as they please. They can change the trust, they can revoke the trust, they can take all the assets out of the trust, so they can do as they please. The second option is that upon the passing of one of you, the entire trust becomes irrevocable. The surviving spouse can continue benefiting from all the assets, but they cannot make any changes to the trust. And the third option is that half of the trust becomes irrevocable and the other trust remains revocable, so the surviving spouse can make changes. Was there any PowerPoint docs that we can have? Yes, I can email the PowerPoint to your board. What is the difference between probate with court confirmation and without? And how long does it take to close a sale with court confirmation and without? This question I normally address during my probate presentation, but I'll go ahead and answer it here. So one of your colleagues is asking, in a probate proceeding, normally if a home is going to be sold, there's two different options. One option is court confirmation is required, meaning in order to sell a home in a probate proceeding, the judge needs to approve the sale terms. In the other situation, when court confirmation is not required, that means that the judge does not need to approve the sale terms. How long do the sales normally, how long does it take for that sale to close? If court confirmation is required, at least 3 months. If court confirmation is not required, it's like your normal transaction. All you need is for all the heirs to consent to the sale terms. Maureen, did state of California recently change the contest rule? Has a contest of trust verbiage been removed from trust? No, I always include in my trust the contest provision. So if someone does contest the trust, they're not entitled to a distribution. What you may be referring to is, I know there was a recent case dealing with who has the authority to contest a trust, but that is way above this presentation, so I'm not going to go into that. Any other questions? When to update a trust, a purchase of a new home, necessary to update after opening new bank account. So the question is, when do I update my trust? You update your trust when there's been a change in your life. Meaning, let's say your trust, you have everything goes in equal shares to your kids, and you have a falling out with one of your kids and you want to disinherit them. Or you've given a lot of money to one child during your lifetime that you say, okay, now I don't want to give them any more money upon my passing. You would change the trust then. However, if during your lifetime you acquire more assets, meaning you buy another home, you open up another bank account, all you need to do is transfer those assets into the name of the trust. So if you buy another home, then you just create a deed transferring ownership into your trust. If you open up another bank account, you need to make sure that that bank account is opened in the name of the trust. So long as those assets are titled in the name of the trust provisions would apply. So in your trust, if you have distributions indicating that at the time of my passing, whatever is left will go in these percentages to these individuals, whatever's in your trust will be distributed to your beneficiaries. If I'm receiving Medi-Cal benefits, what will happen if I prepare a trust? Absolutely nothing. You would actually benefit because upon your passing, Medi-Cal will not file a claim against your probate proceeding because there won't be a probate proceeding. So remember, if you have a trust and you receive Medi-Cal benefits, you will not have to pay that money back. If you receive Medi-Cal benefits and you don't have a trust and you need to go through probate, your children will have to pay every single penny back to Medi-Cal. Maureen, sisters inherited apartments from father and want to keep apartments separate from spouses. Do you recommend a separate trust for the apartments? Yes, and I recommend that they sit down with an attorney and discuss how they're going to manage those apartments, because once the spouses start contributing towards those apartments or they use their salary to improve those apartments, the spouse can allege an interest in those apartments. Cynthia, how long does it take to get a home into a trust once a payment has been processed to initiate complete package? Okay, so in my office, the first step is you schedule consultation. The consultation fee is $80 for an hour. During that appointment, you come into my office, we discuss your situation, we discuss the benefits of a living trust, and I give you an intake sheet. Then you go home and you complete that intake sheet. Once you completed that intake sheet and have thought of all the distributions, you come back for a second appointment. At that appointment, I will take all your instructions and I will create a trust based on the instructions you have provided me. Then you come back to sign your trust, which would be 2 to 3 weeks after that second appointment at my office. Half of the payment is due when you retain my office, and the second half once you sign your trust. Can you send us an intake sheet now? Call my office and have my assistant email it to you. All right, so any other questions? How much does it cost every time someone changes a trust? It depends how extensive the changes are. It could be anywhere from $200 to $500 to make changes. Any other questions? Is it necessary to remove a property after sold? No. You know, even if that property is referenced in your trust, if it's not there, if you don't own it at the time you're passing, you don't need to do anything. You would need to change your trust if you say my house on Green Street goes to my daughter, and then you sell that property and you buy a replacement home and you intend for that replacement home to go to your daughter, you would have to change the trust. Trust has been made, but name of bank account is personal name. Any issues? Yes. All your accounts should be titled in the name of the trust, because if all the money that you have or all the assets outside of the trust, if they exceed a certain amount of money, you will end up in probate court. The pricing for trust, I have it here on this slide. There it is. Single person, $1,649. Married couple, $2,499. Any other questions? Rick, can the current bank account just show the trust as a beneficiary? I would not recommend that, because remember, if something is listed, if someone or a trust is listed as a beneficiary, that means that that interest does not vest until you pass away. One of the purposes of a trust is so that if you were to lose capacity during your lifetime, your successor trustee would have access to all your assets to provide for your care. So if you were to lose capacity and your bank accounts are not titled in the name of the trust, then your successor trustee will not have access to that money for your care. Yes, I am doing in-person appointments at my office. We do prefer phone appointments or Zoom appointments, but we are taking in-person appointments. If you need to schedule an appointment, you can do it on my website. You can call the office too, but payment will be required at the time of booking. Oh no, I don't think I have my website here, but if you just Google Lepe Law Firm, my website will come up. Christine, if someone not related to the trustor is named in a trust to inherit a property, but the property wasn't transferred in the name of the trust, what can friend do to get the property? This is a complicated issue. I can't answer this. I would need to see the trust. I would need to see title to the property. So your friend would need to schedule a consultation. What is the deposit for the trust? Half when you retain me and half when you sign. So the fee that I have here, half of $2,400 would be due at the time when you retain me, and the balance when you sign your trust. All right, any other questions? All right, I think those were all the questions. Thank you for joining us this morning, and stay safe. You're welcome. Bye, everyone.